Well, hello again. And speaking of again, if you look at this list on the screen, mosey on down to HH. And who do you see? It's me. And yet another lawsuit. This time I'm not subpoenaed. An attorney, Mark Tinsley, if you know the Murdoch case at all, you know who he is. And I did an interview with his wife, a two-part interview about her latest podcast. This is just like a discovery demand. Any of his communication with us. I never thought that I would be on a list of people that included the Murdaugh family, the Murdaugh law firm, senators, the Murdaugh defense attorneys, Jim Griffin and Dick Harpootlian. But there's some cool people on here too. There's Eric Bland, another really super famous attorney from the whole Murdaugh thing. And let's see, who else do I recognize? The mother of Stephen Smith, the 2015 murder that is still unsolved to this day. And Mandy Matney and Liz Farrell, that's kind of impressive. They've got their Hulu series out right now. And Valerie Bauerlein from the Wall Street Journal, one of my favorite authors, and another mess of people. So looks like I can't stay out of trouble these days, but he wants any and all communication with everyone on this list, which is ridiculous. But anyway, just thought I'd share that. back in another docket. All right, so what we're doing now is part 2, and I meant to do this all in one, but it turned out to be a little bit longer than I expected it to be. So we stopped at 1 hour and 20 minutes earlier because we are going on to a different topic. So I updated the thumbnail a little bit, and I added the attorneys with their hands out begging for more money. They want sanctions. Will work for food. I almost made a sign that said will work for food, but I thought I better stop there. Yes, dead. That's hilarious, dead poo. Yes, he is a marmot, Jesse. So, what I wanted to talk about, it was supposed to be in the first one, but I couldn't remember at the end what it was that I wanted to say. But here's what I wanted to say. Where is the evidence? So Blake is claiming that there was a smear campaign. And whether the cause of the smear campaign was invisible or not, the effects of the smear campaign should be readily available, right? And so they're demanding that there must be these signal chats to prove that they did in fact implement the smear campaign that they were talking about. Am I having deja vu? I changed it up a little bit, but I didn't have time to make a whole fresh thumbnail, and I thought this one is great anyway. So I just added the attorneys. But there's another conspiracy case that I cover. In fact, it's the one that I just showed you my name on. Here's where that one started. And they're claiming the same thing, a smear campaign, but here's where it started. There was a documentary made that involved one of the defendants in the lawsuit that is accused of this conspiracy, of being the person who financed the whole conspiracy, and financed and ordered. That's what the allegations are. So he's in this along with some of the people who were suspected to have been involved with it. So there's some direct evidence that they were involved in the situation. So besides of that, there were articles put out, and there were some social media things. But here's the thing, they had tangible evidence of a smear campaign existing. And they started with that and worked backwards. If there hadn't been the evidence of this documentary, these appearances on different TV shows, these newspaper articles, things like that, they wouldn't have known that there was a smear campaign. So when they started tracing these things, that's when they were able to find who was involved in it. They've got they've got the PIs now that were doing the investigation. I mean, he is an amazing attorney, and he has scorched earth, gone through, and the story, when it was first told, it sounded just outrageous. Like, how in the world could this possibly be true? It's too strange, it's too bizarre to be believable. But he kept going and he kept going, and he is getting to the bottom of it as we speak. And the trial is about the same time as this one. So they're pretty much in the same places and discovering everything. I think that one might be a little bit later than this one. But it's really exciting to compare these two cases and how different they are, and how this guy, with a story much more bizarre than just a celebrity who's getting talked about. This was a bizarre story, and he was able to track it down. Do you know why? Because the smear campaign actually existed. So what you do is you don't just go, I think there was a smear campaign about me because these people were talking about it. I have no proof that there was a smear campaign, but there was. Trust me. Here's what she needs to do. So they're claiming there were bots. They're claiming that Wayfair and Wayfair's team, Melissa Nathan, Jennifer Abel, and Jed Wallace, were putting this information out there. Well, if they in fact did put that information out there, where is it? There should be something that you can trace to them. But every single account that I've ever seen, every TikTok, every YouTube, every Instagram reel, every post on X is a legit account, an account that existed long before this story, and an account that is still with us today posting. So, where is the actual evidence? Not missing signal messages, not, oh, they said they could bury someone, not, oh, they said it was untraceable, because it's not a smear campaign unless there's actual product at the end. Where are the videos and posts that came from Wayfair's PR people? Where are they? They chased after us content creators, got nothing. They chased after some other ones directly, like Megyn Kelly and Candace Owen and Kirsty Flaw. Nothing. Perez Hilton still going after Popcorn Planet, Last Man Standing. Nothing. So if there was a smear campaign, there should be products of the smear campaign, and they have absolutely nothing. This guy, Mark Tinsley, who has searched this out, he has the articles that they had posted that can be traced back to them. He has the PIs. And one of those PIs used to work for counterintelligence for the United States. If he's done some stuff in the Middle East. This guy is like spy material. And he tracked him down. So what I'm saying is, in this day and age, nothing is truly invisible or untraceable. It's going to be found, and yet they don't have anything. If I tell you my car was vandalized, and then I say, here's my proof. Look at these text messages of people talking about they plan to vandalize my car. Is that proof that my car was actually vandalized? Can I take those messages and go to court and say, look at this, Your Honor, these people vandalized my car. I want to sue them. What is the first thing the judge is going to ask me for? Proof that my car was vandalized, right? I need to show pictures or video or something to show the actual damage to my car. Without the damage to my car, I don't have a case. It doesn't matter how many messages I have or don't have and want to pretend that I have to take to a court of law. It's not going to be good enough to prove that the crime was actually committed. So this is what I keep coming back to. Where's the evidence, the actual evidence that a smear campaign ever came to fruition? All there are out there are actual accounts like mine, like everybody else who was subpoenaed, and we existed long before any of this, and we're still here. And this isn't the only thing we've ever reported on. We organically chose to talk about this person in this case. So that's what she needs to prove, that a smear campaign actually existed. Instead of trying to prove that these signal messages existed, prove to the court that a smear campaign existed. She's got some old posts from Reddit. Well, track those people down. They're real. They legitimately posted about you. And they posted about you long before the movie was out, long before you fell out with anybody in Wayfair. It's absurd to me that a lawsuit has gone on this long with zero evidence that any of it happened. It just that point just drives me crazy. You start at the end, this is the proof that this happened, and then you work your way back. And she wants so badly to prove that they didn't just talk about it, they didn't just plan in the event of. They're like, "No, it happened." Show me the smear campaign. Not all of us talking about you. Show me the Wayfair-based smear campaign. It doesn't exist. It just simply doesn't exist. Yes, there would be payment. There would be communication. There was nothing between those of us who got accused. Nothing like that. Yeah, no one does anything for free. There would at least be transactions and payments. And there would be people who have more than one subscriber. It would have been big accounts. Why would they have reached out to me? I didn't talk about anything like this before. Why would somebody have come to me who exclusively talked about the Murdaugh case and women who had been done away with by their husbands? Why would anybody have approached me and said, "Hey, we want you to write about this case"? It makes no sense. There was a logical explanation for how I ended up covering this case that I talked about a long time ago. And it's just absolutely silly. I had never covered a case anything like this one. I was in the darker side of true crime, not celebrity stuff. But I like talking about David and Goliath sort of cases where the rich and the powerful walk all over the less rich and powerful people. And so I ended up sticking it out with this case, but it really makes no sense. I mean, where is the proof that the proof would not be in signal messages. The proof would be bring me evidence that these people actually successfully put a smear campaign out there, not just some random Reddit messages. And if you're going to consider the random Reddit messages, keep going back, and find out when it started. We were talking about the law that this motion for sanctions falls under, and that was 37E. So if you're just watching this one and you didn't see my earlier one, the earlier one talked about the actual motion. And then I had also done research on the case law that as recited in her motion. And I found some interesting things in that, so I wanted to share that with you. But the first one was going over a little too long, and so I decided to divide it into two. We're back to talk about the rulings, the previous rulings that she put in her motion and how they compare to this case. Now, just a reminder, especially for those who didn't see the earlier one, I'm going to talk a lot about binding authority. Binding authority, just as a review, means if a higher court than the court you're in makes a ruling, anyone beneath that court is bound by that court's decision. So, and I love saying this, and I saw somebody commented that they love hearing it too. The orange court at the bottom left, federal district courts. This is where Lyman is. The U.S. Court of Appeals is above it. So everything that Judge Lyman rules in his court has to be in accordance with any binding decision that was decided in the U.S. Court of Appeals, because it's a higher court than him. That's the whole purpose of the higher courts. Then above that is the federal statutes, and above that is the U.S. Supreme Court. Now, this is all just federal. This isn't state court. So any decision that the U.S. Supreme Court makes, the U.S. Court of Appeals and the federal district courts are bound by those. So it's a definite hierarchy, and that keeps it serves a wonderful purpose of keeping everything unified as much as possible, not just leaving it up to however many district court judges are out there to willy-nilly decide things. So binding authority is very, very important when you're making rulings. Thank you, Summer. What did you say? He's the butt juice. What are we talking about? Lyman is a Lyman is a bottom. He's a butt juice. You guys are just like me. Okay, so keeping that in mind, let's get right into these cases. So these are the cases that Ezra put as persuasive authority for him to rule on. And if you look at that first one, Barbera versus Graylid, it's Judge Lyman. This is a Judge Lyman case. Is he a chicken butt juice? That is the question. Is he a chicken butt juice, though? That is the important question of the day. So this was ruled by Judge Liman just a few months ago while he was already processing this case. That date is important, though, July 25th, 2025, and we will get to that in a moment. Let me write that down in case I forget. Okay, so here's the summary of this case. So she uses this case to claim that severe sanctions, including adverse inference and preclusion, may be appropriate. Oops, I got a typo. Sorry about that. So if you remember, or if you were here for the earlier one, it was already in the rules that you don't jump straight to the severest remedy. First, you try to find another remedy. Can you get copies of this information somewhere else, from another person that might have it, or for some forensic extraction of a device? Something like that. That's where you start. You don't jump straight to tell the jury that even though I don't have evidence, what I say is true, and tell them not to listen to the other side. You don't jump straight to that and then a demand for money. You start at the slightest remedy and then you work your way up and see if there's something else you can come up with. So she says we can go straight to severe because you, Judge Lyman, allowed it to happen in this case just a few months ago. So you need to rule in our favor because you already ruled in our favor in another case, and in the favor of another person parallel to them. But what happened in this case that's different than Blake's? So Barbera was found to have engaged in pervasive discovery misconduct. There was missed and incomplete disclosures. There was a failure to produce documents responsive to discovery. They withheld settlement agreements. That's a much bigger thing there. Deficient verification of interrogatory responses and obstructive conduct that required multiple sanctions motions. This sounds very much like all the things she's trying to claim in this case. And because this is a Judge Liman rule, this one worries me the most. So, what did he rule? He imposed preclusion of testimony. So, he stopped someone from being able to testify about something, which is like what Blake wants. Regarding the discovery date, permission for defendant to present evidence regarding lost documents, another thing Blake has asked for, and monetary sanctions and fees against plaintiff and plaintiff's counsel, including an order to produce withheld settlement agreements unless objected. And here's what he said. Plaintiff will be precluded from testifying regarding the date upon which he initially discovered the alleged infringement, and defendant will be permitted to present evidence and argument to the jury regarding the lost documents. This started to make me really nervous because there are so many similarities. It's not exact. This case does have the settlement agreement thing. And that he did this, like I said, July 25th, just a few months ago, while working on this case. So how do we distinguish it? This case punished extensive discovery avoidance, but again, they're making the claim that that's what Wayfair has done. And I wondered why they exaggerated it so much in this motion. And I think it's specifically because of this Lyman ruling. They're trying to make it look more like it, to make it match this case, where he can look and say, oh yeah, I've been there, done that. Let's do this. Its remedies addressed a record of non-production and delayed deficient discovery, not an ephemeral message theory based on inability to retrieve auto-deleted signal messages, which is considered technical limits of preservation. And Blake claims that messages 6 to 13 months prior to her complaint are lost due to an auto-delete after a certain time was a deliberate act to avoid preservation. But based on this really makes me nervous. So we're going to combat this in a little bit, but we're going to get through the rest of the cases that she cited. So her next case is Karsh versus Blink Health Limited. And this is one of his colleagues, another Southern District of New York judge, Marrero. And this particular ruling was ruled on by a magistrate judge who is named Barbara Moses. So Ezra uses this case to support an adverse inference. And if you weren't in the last one and aren't sure what an adverse inference is, that's when you tell the court they lost this on purpose, and probably because it was damaging to them, so they didn't want you to see it. It's along those lines. But it's an instruction to the jury that looks bad on the person for not producing the evidence. However, plaintiff caused or directed the removal or takedown of a server that contained ESI relevant to the litigation, and that relevant data on that server was lost and therefore unavailable to defendants. This doesn't even compare. I mean, these people took down their entire server to get rid of everything. And Wayfair has not done that. And they have all their messages from the time they were noticed to preserve them. Additionally, plaintiff's counsel received devices from a former client that contained potentially relevant ESI, and the court found that Sanctions' handling of those devices amounted to spoilation because of chain of custody gaps, loss or destruction of data on the devices, and the court also found plaintiff and his counsel failed to comply with several earlier discovery orders. And I believe in this case, this stuff happened during litigation, but I forgot to note that. So as I said, this was ruled over by Marrero, but his magistrate judge, Moses, is the one that took care of the sanction order. And she concluded that the mismanagement of the devices constituted spoilation of ESI, and that defendants were prejudiced by the loss of that evidence. As a remedy, the court permitted defendants to present evidence to the jury about plaintiff's takedown of the server and the loss of the devices and awarded significant attorney's fees and costs as sanctions. Now, the case itself went to appeal. It wasn't about any of the merits, but there was something procedural that happened. And so the appeal was denied. So there's nothing in a higher court about this case because it didn't survive the process of appeal. But I think we can all agree this is quite different from what Blake is claiming of Wayfair. So in the distinguishing factors, I said, seriously, how does taking down a whole server and mishandling devices, destroying chain of custody, and removal of data compare to an auto-delete setting of messages from before litigation? And you'll notice that the rest of these cases, they're all dramatically different from this case. And I meant to go in and look up what sorts of remedies he might have done, or did he have a hearing before he made this decision or what? But maybe later I'll look into that to see if he held a hearing before making this decision, because that might give us an idea about how he might resolve this situation. Will he just sit down with his clerks and just decide this on their own, or will he take more steps to get to the bottom of it? I'm looking up this case might give us a clue about that. So the next case was Addison versus SMBC Leasing and Finance, another case out of SDNY by Judge Sweet. In this case, defendants brought a claim against plaintiff for failing to preserve or produce proof of an alleged background government report central to her claims. At deposition, she admitted that as of November 2013, 8 months after she filed this lawsuit, she had no proof that the report existed. It was something she remembered or had been told about many years before, but never had a copy in her files. Again, a completely different situation. She brought a lawsuit based on a report that she claimed that she had, that she never actually ever had. She claims that she laid eyes on it months before, but never actually had the report. So very, very different situation. That's kind of lying about your evidence in the first place. The court found plaintiff's side spoilation and awarded an adverse inference based on documentary ESI non-production ruling that plaintiff's testimony and other record evidence supported a finding of spoliation and that an adverse inference instruction was warranted because the defendants had been prejudiced by the non-production. In this case, oh, hey, Christina, sorry, I forgot to thank you last time. If I forget at the end of this one, I'll thank you now. In this situation, it wasn't like listen to me without proof and don't listen to them. This was, hey, this report that she's talking about, she says she saw, but she never produced. That's a completely different story. And it's absolutely true. So, I mean, she doesn't even dispute it. So this is a completely different situation. So the distinguishing factors, she brought a case to court knowing she had no such report. It was something she claimed to have seen but never had. So very different from auto-deleting messages from 6 to 13 months before a complaint was filed. The next few cases, because this possibly will fall under California law, I've got some California cases in here too, or she's got some California cases in here too, and I will have some as well. This one is Google Play Store antitrust litigation, and this was Judge Donato in the Northern District of California. Let's see how they rule over there. So the ephemeral data at issue was internal corporate chat and messaging platform. Oh, so many typos. I typed this like 2 o'clock in the morning, so sorry about the typos. Primarily Google's internal chat systems. Now these are exactly that. They are messages that auto-delete. Group chats and one-to-one messages and related ephemeral message streams and logs likely to contain probative evidence about Google's conduct and internal decision-making. Some custodial message streams and associated metadata were not fully searched, imaged, or produced. There were gaps in the custodial or IT preservation protocols leaving the timing and scope of deletions unclear, as well as insufficient documentation of preservation steps, forensic collection, or chain of custody for deleted data and logs. So in this situation, it's not just that the system itself auto-deleted like we have in the Wayfarer case. In this case, they were not handling the evidence correctly. They didn't have proper chain of custody. They didn't do the proper steps. The metadata wasn't there to find out when these things were deleted. It's a whole different situation. These are things that are manually done. And to me, and to what I found in the law, there's a big difference between things that are manually deleted, where someone has gone in and said, I'm deleting this specific message, and a system that just auto deletes, that nobody actually did it. It's a whole different thing. So the ruling in this case, the court entered judgment following a jury verdict that Google violated federal and California antitrust law in the Android app distribution and in-app billing markets, and it issued a 3-year permanent injunction restricting Google from providing certain benefits that advantage the Google Play Store and from tying Play Store use to Google Play billing. These, for what happened here, these are very reasonable. There's nothing severe about this. And the distinguishing factors, the auto-delete continued into actual litigation in this case, whereas Wayfarer's messages were pre-litigation. So these protocols being ignored and the chain of custody and not preserving metadata, this happened during the actual litigation, where they absolutely knew that they were supposed to be preserving this stuff. So we have an entirely different situation. And also this case included those gaps in protocol, insufficient documentation, collection, and chain of custody. The next one, also from the Northern District of California, is WeRide versus Qin Huang. So defendants allegedly purged emails and wiped laptops and servers containing potentially relevant source code and other files both before and after litigation was filed. Defendants allegedly failed to take proactive preservation steps, including noncompliance with the preliminary injunction that expressly prohibited destroying, concealing, disposing, deleting, removing, or altering evidence. The misconduct included affirmative destruction and omission, affirmative deletion, wiping, and failures to preserve or produce relevant electronic evidence and logs that would show what was deleted and when. I mean, come on, this is bold. This is after litigation, when they've expressly been told, do not destroy, conceal, dispose, delete, remove, or alter any of this. And they're like, okay, we're just going to purge this and wipe the server. And it's completely different. Very, very deliberate. And after litigation had begun. And so the court's, this is a sanctions package, included entry of default as an available sanction tied to the spoliation and orders for defendants to pay WeRide's attorney's fees and costs related to the motion. WeRide later sought nearly $2 million in fees and costs tied to the spoliation proceedings. The court treated the conduct as severe because it both affirmatively destroyed evidence and failed to preserve evidence once preservation obligations and the preliminary injunction were in place. Absolutely deliberate, inexcusable conduct here. There's no question that what they deleted was going to be bad, because, I mean, who does that? WeRide, apparently. Then we have Victor Stanley Inc. versus Creative Pipe, and this is back in the Southern District, and this was ruled on by a magistrate judge. This was intentional deletion and destruction of large amounts of ESI relevant to the claims that Creative Pipe and its principals copied Victor Stanley's design drawings and specifications, including deletion of relevant downloads, CAD files, and logs showing access to Victor Stanley's online product library. There was a pattern of evasive conduct by defendants that the court characterized as extensive and highly prejudicial to Victor Stanley's ability to prosecute claims. Again, this is nothing like Wayfair. This is intentional deletion and destruction of large amounts of proof. Apparently, this was copyright or stolen creation of someone, and it's very obvious that they went in there to cover their tracks. This was all deliberate, manually done, and it also says these occurred around key discovery events, and there was a pattern of evasive conduct. And so, in this case, the magistrate it resulted in severe sanctions against defendants, including default liability on certain claims and other adverse consequences. The magistrate's opinion characterized the deletion as warranting strong remedial measures, describing the conduct, as among the most egregious spoliation he had seen. Certainly, auto-deleted messages that nobody manually did is not egregious spoliation. That this case should be put on this motion in order to say, well, hey, look what they ruled in this case. You should rule this way too. So of all of those cases, everything was very severe. The spoliation, was very, very severe, not coming anywhere close to Wayfair. And I think that's alarming. This case, and remember I taught you when you see 2D CIR, that's the Second Circuit. Going back to the map or the chart, the Second Circuit is the green Court of Appeals above Judge Liman's orange court at the bottom. What does it say next to it? Binding in its circuit. What that means, as I keep saying, if this case exists, Liman has to use it in his decision. He's bound by it. And when these higher courts make these rulings, it's on the court website. It is the judge and the judge's clerk's responsibilities to keep up with those. They are supposed to regularly check in to see if there's new binding authority, make note of it, make sure to follow it in the future. So on the 17th, there was binding authority made on this very subject. So this case right here, as it sits in the Second Circuit, which is his circuit, he is bound by it. This happened. ELG. This is the binding authority, and he should follow in this case. We'll see if he does. But this is what he needs to use as his binding authority when he answers Blake's motion. So I want you guys to remember what this ruling says. This is his circuit, okay? They came up with a requirement that only intentional deprivation supports the harshest remedies. Intentional deprivation must be proven. How's he going to prove that? This is why I think there might be at some point a hearing, either something they do behind the scenes or something we get to listen to. I don't know, but how else is he going to prove whether or not this Wayfair intentionally deprived Blake of this stuff? But this is what he's required to consider. Okay, so these are some quotes from that case that is now case law binding authority. It says Rule 37E controls spoliation of ESI. Courts must address whether a preservation duty attached, whether reasonable steps were taken after that point. So he's going to have to consider this seriously, not because Ezra said so, because Blake said so, but was there a true and binding preservation duty? So that's another thing he's going to have to prove by standard of law that it existed. Whether reasonable steps were taken, not before, after that point. So this is the thing he's going to have to determine. When was that preservation duty in force? Whether the lost ESI can be restored or replaced, Blake already said Skyline has the messages. So that could be the solution. Go straight to Skyline then. Why does it have to be from these people? And I just wonder what the Skyline ones are. They're obviously not very good, or she would have been satisfied with them. She thinks there's still something out there, which means she doesn't have the proof that she needs. And whether the party acted with intent to deprive when assessing severe sanctions. So it said that at the top, but let me stress that again. Proving intent is not a little thing. That has requirements by law of how to prove it. It's not something he can sit in his office and just think about. So this is what he's got to do. Another quote from the case: where lost ESI causes prejudice, Rule 37E1 authorizes measures no greater than necessary to cure the prejudice. You don't jump straight to severe. You take the littlest one necessary. So, oh, someone else has those messages? Oh, good. Let's do that. Oh, they auto deleted. You didn't change the setting. That's a different situation than someone wiping out a whole server. Only where the spoilating party acted with intent to deprive may a court impose the extreme measures in Rule 37E2. And I think a judge would be hard-pressed to say that there was an intent to deprive when a device auto-deleted a message because of the passage of time, because they were from so long ago, before these people were told to preserve anything. Let's try to remember this case and see how he decides, because this is how he's supposed to rule based on all of this criteria we just saw. The next one, these two are from the Ninth Circuit, which is California. Well, California is included in those. The whole West Coast, basically, up and down in a couple of states. It's a pretty big circuit, actually, but a lot of it is desert. So, okay, Jones versus Riot Hospitality Group. This was decided in 2024, and this is another important bit. It needs to be cases that were decided after 2015, when the law changed. When the law changes, it kind of makes the previous ones moot, because they're based on a different criteria. So that's another important thing. These are all current, and these are all higher court rulings from the Court of Appeals. All right, so Jones versus Riot sets a two-pronged standard taken directly from the statute. To dismiss a case under Rule 37E2, a district court need only find that the Rule 37E prerequisites are met. The spoilating party acted with the intent required under Rule 37E2, and lesser sanctions are insufficient to address the loss of the ESI. So written up a little bit differently, but the same as what was said in ELG, because both of these judges are considering the actual statute with their decision. Intent, and is there an easier, lesser sanction to cure this? So auto-delete policies are one factor, but without proof of intent or unreplaceable prejudice, the rule restricts relief. According to this, he cannot just jump straight to those severe sanctions. All of this has to be met first. And frankly, from a legal standpoint, it just doesn't meet this burden. And then we have Gregory versus State of Montana, again, the Ninth Circuit. So if he rules according to California, that's California's circuit. Gregory makes plain that a court may not circumvent Rule 37E by invoking inherent authority. Remember that, we're going to get to that. To impose the same type of adverse relief where the rule applies. Recklessness is insufficient to impose the severe remedial options listed in Rule 37E2. So they say different things that are really, really important. Recklessness. You didn't notice that you had auto delete set and the things just got auto deleted. That could be at best considered recklessness. But these people hadn't been told to preserve anything yet. I still hold to that. And that inherent authority we're going to get to. The quotes from there is, by its plain terms, Federal Rule of Civil Procedure 37E2 displaces the district court's power to invoke inherent authority in fashioning sanctions for the sort of failure to preserve electronically stored information that occurred in this case. So, what is inherent authority? These statutes clearly preclude that. So, let's look into what inherent authority is. It is a court's own power derived from its existence as a court. So we've seen in a lot of things that we've talked about that say that it falls under the authority of the court. So judges are given a lot of leeway because every case none of them are exactly the same to a previous case. So there are situations where there aren't like hard and fast rules. The call is left up to the judge, and that's called inherent authority. Now, inherent authority is way, 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 way down. It's never supposed to be applied in opposition to any of the rest of this. It is not unlimited. Judges, especially in the lowest court, do not have unlimited power. They are bound by rules and higher rulings. Sorry, hold on. It cannot be used to override clear statutory or rule-based requirements and should be used sparingly. What does that mean in this case? What they just said here, this Gregory versus State of Montana, very clearly, a judge does not have the authority to use his own decision-making power to override this binding authority. In the motion to dismiss, when he's explaining his decision, that's what he uses. He sees there's a U.S. Supreme Court ruling that he has in his document. He ignores the U.S. Court of Appeals ruling, both of those. He was bound by law, swore an oath to comply with this stuff, ignored them and said, well, here in the Southern District of New York, we see it like this, and then used his inherent authority as if it were a higher authority than the U.S. Supreme Court, the statutes, and the U.S. Court of Appeals. Yes. I think Blake is extra mad that Steve called ScarJo nice and cool and calm and called Blake different. Yep. That had to have been magnified when Andy Cohen said, what's her name? Right. Yeah, Justin Baldoni and what's her name? I bet he's got he would have had a subpoena, but discovery's over. I was like, oh, the next motion filed is going to be an extension to send a subpoena to Andy Cohen. Roses Wild says that is the scariest part about what Blake is now asking. It will give Liman another opportunity to litigate for Blake and pretend to be her lawyer again. And that makes his face watch. Yeah, we've all seen him. We've seen him lawyer for her. Mm-hmm. What's crazy is that they're saying Wayfarer knew since November 2023 that there could be litigation. If Blake hated her job that much, why didn't she use her contract to get out of it? Exactly. Didn't she say that she had no intention of bringing a lawsuit? So until something, I forgot what it was that happened. So why should they have been ready for something that wasn't going to happen? Thank you so much, Mr. Lord. You are so generous. Yes, Judge Arthur Liman was in charge of the Iran-Contra affair. You've said that before, and I never looked into that. I forgot about it, and now you just reminded me again. Yeah, he was big stuff. And someone said there were Hollywood connections, but I have not verified that myself yet. Very good point, Copper Mountain. Can you believe this is all coming from a girl who told Taylor Swift to delete her text messages? Yes. The nerve of these people, and Stephanie Jones as well jumping in on this. Oh, I forgot to update this one to the new. There we go. Let's put the new one with the lawyers begging for money for sanctions all the time. What is it? Seven sanction motions already? Or am I exaggerating it? That's a lot. To me, that's frivolous. It's time to, time for them to be told to knock it off. He hasn't even ruled on most of them yet, or any of them. He hasn't ruled on any of them, right? I'm not sure about that. Don't quote me. But basically, this motion, oh, Christina said she believes it's 7. Yeah, I thought it was 7. So basically, this motion, this is what it is. And then we've got the absolute fear of Judge Liman using his inherent authority instead of the statute and instead of the binding authority. So we'll have to wait and see what comes of this. But only his went straight to severe out of all those cases listed. Only his. And the others were much different situations than the allegations in this one. So no, and I have watched now since mine. I don't like to watch anybody else's take on something until I do my own because I don't want to be influenced by anybody else and what they think or what they come up with. I want mine to be my own and different. But I did go watch Little Girl Attorney because she's my absolute favorite. And yeah, she seems to think this is all just Blake has no evidence. And so she put this out there and that it's desperate and ridiculous. And yeah, she does not have the proper evidence to say there's definitely something there in those signal messages or that those messages even exist and that they prove her case and that the judge should therefore believe her even though they don't exist and not even let the defendants defend themselves. It's insanity. Like I said in the earlier one, what's the point of trial? What's the point of trial if the judge is going to instruct the jury so? It is an embarrassment. It is an embarrassment, but some certain people they're not capable of being embarrassed. Lady Dias, was there a ruling on this already? No, not yet. Wayfarer gets to reply first, and then he'll rule. He might just file it away with the rest of them and get to it later, but I don't know what's going to happen. But now you all know binding authority. You know what he has to go by when he makes this decision. So hold him to it. Thank you again, Summer and Mr. Lord. And thank you, Christina. I didn't see Jane or Lena in this one, but if I missed you guys, because I wasn't really paying attention to the chat, but if I missed you guys, thank you too. But thank you, Christina. I'll thank you twice because I forgot to thank you and Jane from the earlier one until after I went off the live. So guys, I hope that explains a little bit more about what this kind of entails, what it means. Does anybody have any more questions about Okay, Jesse and Max has a very serious question. So we all got to get really serious now. And I need all my legal books to answer. All right, so let me research real quick. Do you think Ryan knows he's orange? I don't know. I think he does now because I think a lot of us have talked about it. I think enough of us have talked about it. Mr. Lord, thank you again. Remember Peabody. All right, you know what? I'm writing it down. I'm writing it down because I will forget. What? I'm not wearing socks. What is going on? No, he did not, Hens. Hens asked, did Lyman rule on Kenz's sanctions? No, nor on mine, nor on Lauren's, nor on Leanne's, nor on Ashley's. I don't know if I missed. I don't know if Sweet and Salty Lynn filed one too. I forgot who all did it. I know there was like 5 of us that submitted those around the same time. And then Ken's, I think Ken's has done 2 since then. So, no, he has ignored them all. And Ezra She also didn't respond. She should have put a reply in there, but she didn't. I don't think she wanted attention drawn to it because our legal theories were sound, and she knew it. She knew there was nothing she could say. Yeah, Lauren was one of them. She put a little with her footnote fetish, she put a little footnote in one of her motions that never saw the light of day. The judge just completely ignored it. But the the document it was in, I can't even remember what it was in. It had nothing to do with the subpoenas, nothing. She just put it in there, this little like, "Hey, judge, read my footnote and do me a little favor on the sly, but I'm not going to address this in a big ol' motion because I don't want to draw attention to it." It was just really sickening. Is that just not Gypsy Rose? No, Fab. Fab wants to know if that's Gypsy Rose in the thumbnail as an attorney. No, that is that Meryl? These are all the actual Manette attorneys. I forgot to put Samantha in there because she's not working on the case anymore, but because she is the author of Van Zandt, she has an honorary position that should have been there. No, she should have been there with toilet paper about to wipe Ryan's bottom. That's where I should have put her next time. Girly says, footnote fetish, making it to merch. Justin hit back, according to Andy just now. Hit back about this motion for sanctions. Oh, I gotta go look. Iran-Contra was 1986, 1987, and for months, nothing else was on TV. And Peabody, not the Peabody Award. I didn't know what was going on. He was something else and the smartest person on earth. And he looked like the cartoon character of Peabody. Now I gotta find Peabody cartoon and Iran-Contra. All right, I guess we gotta go look at the docket. A lot of foot action. All right, I was just looking through to see if anybody had any more questions before I log off. No, we can't. I mean, he should have addressed them. Their motions in his court. They were reasonable asks. He might, at the very end, just say it's moot. Because there's nothing, I mean, there's nothing to be done now. The subpoena is no longer enforceable anywhere. I think he specifically didn't rule on it so she could keep using it. That's just my opinion. Yes, that's what she wanted. Rose's wild side, Ezra didn't respond because of her earlier letter where she asked them to be moot. As soon as she got our motions, and it's hilarious that we, without attorneys, just wrote these things ourselves, and we beat this $2,000 an hour plus cost attorney because we were on the right side of the law. That subpoena was not a proper subpoena by any stretch of the imagination. And we told the court all the reasons why, and it came out under his authority. But before he had a chance to rule on them, she made sure and withdrew them every single time. As soon as one of us put in our motion, she withdrew it. On just that person, though, because she did not want an actual ruling. Because if there was an actual ruling brought against that subpoena, she would have had to stop using it, and she didn't want that to happen. Now, I've heard of Ollie North. Ollie North took the fall. They tried to blame it on Peabody, and over a weekend, he came in with all the receipts. You are really going to sell this case to me, aren't you? Costco attorney, Lady Di. Yep, that Costco subpoena. They do have good pants, though. I was talking about my Costco pants earlier. Alrighty, guys. Thank you so much for coming back. And you are now armed with the binding authority that he needs to follow. And let's see if he does. And if he doesn't, we're going to call him out. All right, guys. Have a great evening. Thanks again, Christina. And I'll see you guys later.